Preview.
Good evening, ladies and gentlemen. My name is Pei, and this is IP News. These days, the market for patent technology is surging because of a revolutionary intellectual property right dispute between inventor A and company B. Specifically, on August 2nd, inventor A and company B, both parties developed an invention of a time machine, and both have the purposes of using this time machine to make profits. They both apply for patent protection at the National Office of Intellectual Property of Vietnam. However, company B is qualified for the patent protection, but inventor A is not. For more details, we would like to contact reporter 10 presenting at the courthouse.
Good evening, everyone. I'm reporter Tent, and I'm currently in court to hear a dispute over intellectual property rights for the invention of the time machine between company B and inventor A. After 2 weeks of consideration in trial, the outcome of the dispute is gradually coming to an end, with the victory in favor of company B, because they have the upper hand incapable of industrial application. For basic information of patent registration, today we have invited Professor Protection, the Deputy Director of IP Department of Hanoi, and we would love to provide some conditions from the official IP laws of Vietnam.
Thanks, Reporter Ten. So glad to be here in order to acquire a patent for an invention. According to number 58, term 1, conditions of protection for inventions. An invention is protected in the form of a patent if the following conditions are met: having a novelty, having a creative level, and the last one is capability of industrial application. Further explanation are included in number 60, 61, and 62 of the same term. For novelty, an invention is considered novel if it has not been publicly disclosed in the form of use, written description, or any other form in the country or abroad before the date of filing the patent application or before the invention. Priority date in case the patent application enjoys the right of priority. An invention is considered undisclosed if only a limited number of people know about it and are obliged to keep it secret. An invention should not be deemed to have lost its novelty if it is publicly disclosed by a person entitled to registration as provided for Article 86 of this law, or by a person who obtains information about the invention directly or indirectly from such person, provided that patent applications are filed in Vietnam within 12 months from the date of disclosure. For the creative level, an invention is considered to have an inventive level if it is based on the technical solutions that have been publicly disclosed in the form of use, written description, or in any other form at home or abroad, other than prior to filing date or prior to the priority date of the patent application, in which case the patent application enjoys priority. The invention is an inventive step which cannot be created easily for a person with average knowledge of the respective technical field. The capable of industrial application, an invention is considered to be industrially applicable if it can be made possibly to manufacture, mass produce the product, or repeatedly apply the process to which the invention is concerned, and a stable result can be obtained.
And that's all for the conditions to acquire a patent protection. And in the case of company A and inventor B, according to the report, I believe that inventor B, when applied for the patent, has lacked the condition of capable of industrial application because a scientist may not have the point of view of mass production of the machines as a huge corporations as A. That is all for this case, and that is all for IP News this week. See you next week when we cover another case of IP protection law.